Hi, Bill Henshaw here again, addressing my friends with some new videos based on current events and some other things that have been going on. And we're going to start out with some more shenanigans in the traffic court. And my gosh, it's even beyond belief to me. And if I show my age a little bit here, I'm going to say it's actually beyond Barney Fife, crying out loud. What these idiots are doing. I've got a friend of mine I'm helping out here in California, and the Merced case. This is Merced case number 2, and they're digging a deeper hole here. They're already halfway to China as it is. But he went in for a quote unquote trial today. By the way, it should be noted he was there last Thursday. They finally put his motion to dismiss on the calendar, which had been filed from day one. So that's there, his notice of denial of assistance of counsel, bill of particulars, all of it. The DA never responded to it, despite constructively being given much more time to do it. Not a word. He shows up at this quote unquote hearing to find out everything has been summarily dismissed without any statement of decision, which in my view would be required in a criminal case, which is exactly what this is. For those of you in California, and to the extent that I might use statutory citations, Section 632 of the Code of Civil Procedure, an unopposed motion got denied. Where I come from, we call that A, reversible error, and or B, a directed verdict of guilt. So this is Thursday. The trial date, quote unquote, is set for Tuesday. 2 work days. I mean, there's not even time to take an appeal, even if you can take an appeal, and I'm convinced you can't, by the way. That's not to say there are not some appellate remedies, but appeal ain't one of them. But there's no time for him to do this. This is a pro per litigant, pesky pro per litigant, who has properly refused counsel. He had a 16-page notice of denial of assistance to counsel that set forth the principles of the unopposed issue that I use here. And I've got 4 or 5 of these unopposed issues. All of them are real buttes. And you can learn more about that by sending me an email, ccaspari@live.com. Ask about information on my docket packets like my friend in Merced got a hold of, and see what happens when you try to file them in your case. Now, he actually got them filed. So, unopposed. So he goes into what was supposed to be a trial, quote unquote, today. A DA shows up, which is the first time I've ever heard of such a thing in a California traffic court. Now, I'm not saying it hadn't happened, but in 4 decades I haven't seen that happen. And the DA, without notice or opportunity or anything, moves to dismiss the trial judge, quote unquote judge, for being biased and prejudiced. And again, those of you that use statutory citations, this is section 170.6 of the Code of Civil Procedure. And in theory, you do get one of those, you can peremptorily dismiss anybody. But to do this under the circumstances of this case, with all the BS that's already going on, and the judge ruling in favor of the government each and every time it came up, I would love to see the factual foundation and legal basis for this, let alone the notice to my friend that such a motion was going to be made. If we tried to do that, you'd be damn sure it would be opposed on the grounds of lack of service process. So here we are. The quote-unquote trial has been scheduled for tomorrow, if it happens. And between you and me, to the listeners out there and the viewers, I think what's going to happen is they're going to dismiss the case, either in the interest of justice when the thug or the cop doesn't show up. And notice they never get charged with a willful failure to appear, do they? Like what happens to you when you don't show up. And the hell of that is they can't come anywhere close to proving willful, which is a story for another day. But they're either going to do that or, believe it or not, and this is where I say it gets past Barney Fife, the DA may make us what's called a sua sponte motion on their own order without having to tell you anything about it, and urge the court to dismiss the case for a violation of the defendant's right to a speedy trial, which is 45 days. This case has been going on for 5 or 6 months. It's just been one thing after another. I'll have a full report on another video about this. It's been incredible out there. And to go hand in glove with my first Merced case, in which they did not file any of the documents, and we get back a blank form which looks like something the Judicial Council promulgated, but they didn't. And it says notice of denial of request without telling my friend what the request was, not returning the documents. And it says on the bottom, in effect, please pay this amount, send it at your earliest convenience. Well, they're in so much trouble here. We would win a civil rights case, quote unquote, if I were to bring one like that. And I may do it in part, and if I do it, you'll hear more about that, on one of the upcoming videos and or on one of my talk show programs. And my next appearance there, by the way, is set for July 12th. This will almost certainly not be a subject for that one, but you'll hear about it if I do it. Because once we turn the corner on offensive and start to be able to get redress of grievance, this is what changes the system, how they work. Because now you're going to get judgments against them. People may start losing their retirements, their houses, and whatever. Some of them might even get thrown into jail. I mean, we have that kind of power, and we damn well should be starting to exercise it. That's what I've been working so hard at. And I think I'm closer than anyone that has been in probably over 100 years to actually breaking through on the offensive side. And the big reason for it is that if you get my document packets and file these or attempt to file them in trial court, now, one way or the other, when we get to an offensive case, the only thing before the jury is going to be that unopposed record. Even if they had an affirmative defense, and trust me, they don't. They can't present it. They had their chance in the trial court, didn't they? And you let you and me do that, and what do they tell you? You failed to file timely, it's not properly before the court, see you later. Why doesn't it work both ways? So they had not only a full and fair chance to do it, they had the constitutionally sworn duty to sustain burden of proof on jurisdiction and venue. That's virtually the whole point of the Bill of Particulars, is to force them to do that, and they can't do it. It's as simple as that. They can't. So here we are. So this Merced stuff, I'll be taking a little trip out there. I don't know exactly what time frame. Almost certainly before my next talk show appearance. So what did I say? July 12th, I believe. I'll be out there before and nosing around some offices there and see what the heck is going on there. Why they don't seem to think they're in any trouble. And between you and me, I think the reason is they assume all there is civil rights cases, and they know, quote unquote, that in that setting they have qualified, if not absolute immunity from any and all acts of perjury, any and all acts of admissions, you name it. Doesn't matter. They have immunity. They don't have it in these cases, because we make the point right off the bat and get it to a jury that what they're claiming is judicial immunity, which cannot possibly exist in a legislative tribunal, which is a fact that they should have known. I mean, they took the oath of office to be bound by this Constitution and laws made in pursuance thereof. So therefore, they're not only bound to know it, but just like the black robe bastards tell us, the pesky pro litigants, in court, what do they tell us? Ignorance of the law is no excuse. We're going to fire it right back at them broadside on the offensive side. And with them having taken that oath of office, it gets even worse. So I don't want this video to run on too long here and get into too many side things, but trust me, I'll have updates on this as they go along. They could happen quickly. I'll let you know when they do. Thank you.